stories unfold, and the chat's got soul. From the gavel to the gas, we're watching it all. Covering the courtroom, big case or small. Laugh when we can, cry when we must, but it's all real talk, you can count on us. We're not the pros, just fans who care, with popcorn in hand and a comfy chair. And every twist, we're right there, together like we're all in the witness chair. This is the Broken Baker, where the trials come alive, where the chat is wild and the vibes survive. We're watching the worst of what people do, but we keep it light, yeah, that's our truth. It's the only place for crime, and it feels just right. We bring the justice talk into your night, so hit that stream, don't miss the call. At the Broken Baker, we cover it all. Oh yeah. We're just flaming with the view, but we ask the things the world wants to. Digging through the facts, side by side. Even when it's dark, we bring the light. No clickbait, no fake feels, just truth and the highs and the reels. With the chat that roasts and rise, we're just here for the case and the vibes. This is the Broken Baker, where the stories unfold, with a smile in the heart, even when it's cold. Yeah, we cover the bad with a wink and a grin, where the real talk starts, come on, jump in. It's the only place to be, can't you see? For trials and truth, it's BBTV. The Broken Baker, where the trials come alive. Yeah, we'll be here, trial after trial. Yeah.
Good morning, good evening, good afternoon, wherever you are, whoever you are, maybe something, and welcome to hopefully the same Zoom link as last week, or the 21st, because today is the day where Rosemary is facing off against Lally if he doesn't win his motion to not say anything, and Proctor. Proctor, so far that I know of, have not filed any motion, so he can't talk. But if you weren't watching my morning show, or, well, late night for Americans, or watching my video about it, Lally have filed a motion to try and limit the scope of the questions she can ask. On what ground do you ask? Well, because he doesn't believe that the defense have any standing to file a motion to dismiss, because even though he did turn over evidence late, he did turn it over. So, hey, you can just remedy that by going to court. No problem. So the only thing he wants to be asked about is the egregious, well, how bad of a job they did. And he will then claim, well, I did everything. I had my system. And she will then say, but you didn't turn over shit to us. Well, I did everything I should because I have my system. And he will be just as annoying as last time, not answering questions in any affirmative way, because Lally is a career bureaucrat. One of the things career bureaucrats are good at is being slimy like eels. Nothing sticks to them. He is being a little chicken dropping. Hey, fellas. Hey, True Crime Grammy. Hey, only. I always forget the time difference. We are on the East Coast, think the entire world operates. Well, my channel operates on Eastern Standard Time because that's the easiest. That's where my biggest audience is. That's where I cover most cases. And it makes it way easier when I have 10 Danish subscribers, and we're getting close to 19,000. Could be really fun if you just got me those 1,300 more, so I could reach 20,000 by my channel birthday. No pressure. Sup, Baker, my baby girl? We're watching the pool feed cam or the Zoom? Well, I don't have the pool feed cam. I think I have the Zoom because according to what Marissa was told, it is the same Zoom every time. But she can't get a hold of the clerk at the court today. So isn't it funny? Get your marshmallows ready. There should be some fire, Lally, and Proctor's pants mainly. I'm just worried that we are going to open up and the judge is going to say, well, new policy in Massachusetts, go fuck yourself. You can't watch this. And that's my problem. Go Bucks. Maybe. Why are our names dumb? Get it together, YouTube. Tell YouTube I can't change it. On the 7th of September, Danish Veterans Day. Well, I'm not a girl. I know you can't assume anything in 2025, but I am a guy. Is YouTube still glitchy? I feel like chat is being funky. I don't know. It looks fine on my end. Hey, Hyacinth. Hey, Sammy. What's up? You're up. I'm worried about that too. That seems to be the new standard operating procedure to keep the shenanigans hidden. Yes. And the question is because last time CBS 10, maybe NBC 10, whatever, was also streaming this, and they are real journalism. So perhaps they won't do it. I am a media production company, so technically, shouldn't I be allowed to have feeds and stuff like that? Um, yeah. Hey, therapist, we can do it. Oh, by then. Okay. Hey, gal. No, but it seems like they have sadly learned the wrong lesson from the Karen Reed trial. That we better hide everything, and that's why it's kind of important that you keep the pressure on. Because they will try and hide as much as possible. The more they can hide of Aiden's trial, the better it is for them. But the more people who ask for it, demands it, the more pressure there will be on the courts to not hide behind these stupid rules. I know they don't. Michael Proctor expected in court Tuesday for getaway. Despite ending months ago, the Karen Reed murder case continues to loom over Norfolk Superior Court. On Tuesday, the lead investigator in the case, Michael Proctor, will return for a separate murder case. Oh, it's just this one. I agree. And I'm now in the holding area for the Zoom. And yes, Marissa, I have this. I'm now in the holding area for the Zoom again. Can you hear court? Can you hear court? Tom is here. There's no sound right now. I'm muted. I'm just gonna stop sharing this screen and then I'm sharing it again because I have to do it a stupid way with Zoom. Mhm. Nope, I did the stupid thing again. Share audio. Share. There's no audio from court right now. Well, I just have the spinny wheel on NBC 10. Hey, peace. Oh, you can hear Discord. Of course you can. I'm going to mute Discord. Mute conversation. Should I turn it back on? Hey, Brett. Yeah, let's do it. Bum, 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 bum. That's DUI Jim's forehead as the last time. Just gone 11 p.m. Well, we're glad you're here, Opal Gypsy. Da, 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 da. Why is this Susan Irvin? Does that make sense? Interested Massachusetts resident. Oh, cool name. They will allow this proceeding to be shown. This is a public hearing. Yeah, well, so was the Lindsay Gattani trial, and they pulled the plug on that one because that's a public hearing as well. Yes, Jim had a DUI as well. He's in Massachusetts. You can't live in Massachusetts without DUI.
Session, please be seated.
Judge, docket number 21CR320, the Commonwealth versus Myles King. Can I have counsel identify
Can you hear
themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Michael McGee for the Commonwealth.
Okay,
Good morning, Your Honor. Jennifer Hickman on behalf of the Commonwealth.
thank you,
Good morning, Your Honor. Rosemary Spicchio on behalf of Mr. King.
thank you.
Good morning, Your Honor. Nicole Capici on behalf of Mr. King.
All right,
Good afternoon.
Mr. King,
Can you all hear it?
okay.
Have a seat. And Your Honor, I represent Adam Lally, Pat Hanley.
Your name again?
Pat Hanley.
Okay, thank you.
Thank you.
Okay, I think we first need to deal with the scheduling stuff. I got a number of motions to continue the hearing that's scheduled for noon. I know Ms. Capiccio indicated to the clerk she objects to the continuance.
Yes, Judge, my client, Mr. Johnson, is in the lockup. If we're gonna, I didn't know we were gonna deal with it right now. If we are,
Okay.
could he be brought in?
I think, given the situation we've got, I mean, I don't want to put this over until noon to deal with this.
Good, Your Honor.
I understand that the Commonwealth has a meeting set up for this afternoon, or?
Our counsel informed me that the U.S. Attorney's Office would speak with us at 4 o'clock today.
Okay,
I did have a meeting or a phone call with them last week where I explained procedurally where we were with the variety of different cases, as well as the concerns expressed by you, Your Honor, and Judge Fournier. So they were aware of our requests, the various courts' requests, statements that defense counsel had made in court, and they were aware that there was a hearing that was scheduled last week in front of Judge Fournier and of today's hearing at noon. And we reached out to them last Friday in anticipation of the hearing before Judge Fournier, and we're told that we could have a call today at 4 o'clock. So I apologize that I don't have more information at noon today, but it just doesn't make sense to me to appear at noon and ask for more time.
right. And that's why, to the extent we were able to cancel some of the folks from being brought in, we tried to do that yesterday.
Thank you.
I understand Mr. Johnson is here, and I apologize for him being brought in, but it seems to me that we ought to move this to a date that is viable for
Yes.
everybody next week.
So Judge,
I
can
talked
I just be
about
heard
it this
very briefly?
You
last
may.
night.
Thank you. So I had a conversation with Michael Sullivan, who represents the Norfolk County District Attorney's Office. I had a conversation with the Assistant U.S. Attorney Lamacchia. My biggest concern is whether or not it's been communicated to the U.S. Attorney's Office and or the
Yes.
federal judge that you and Judge Frenier and everybody else are looking for this February 2024 order. When I had that conversation with Assistant United States Attorney Lamacchia, he didn't indicate that there was a conversation one way or the other. What he said to me is he needed to speak to Mr. Sullivan, and then he would get back to me. When I called again, I didn't get something affirmative in terms of, is that being discussed amongst the things that need to get resolved? Because this court has made it clear that you're not inclined to make a decision on my request for discovery until we get that order. And I just want to make sure we're not waiting until next week, and then all of a sudden someone says, now we need the order. So to the extent
I would like to
It
see
won't
the
work for me.
February
I
order.
just get spinning
And
wheels.
I
Okay.
say that
I
to
might be
them.
geolocked.
But I also have to deal with the issue of whether,
There's supposed to be 2 hearings in the Walls case.
regardless of what the
King's
order
case
says,
today.
whether there's still a constitutional obligation on the DA's office to review the information that they are in possession of to determine whether it contains exculpatory information that should be produced in other cases. I appreciate the fact that somebody says you can't look at this or you can only look at it for a limited purpose, but I'm not sure that trumps the constitutional obligation that the DA's office has to review stuff. I'm trying to avoid having to decide that if we can get the authorization from the federal court so that we don't have conflicting orders, but we're not there quite yet. We need to run it to ground a little bit more, and hopefully we can get some movement this afternoon. I think I told everybody last time, out through the 11th. So I'm back the 12th. I'll see you the 12th. I'll see you the 13th. Whatever is convenient for everybody to get back together. I think...
Judge, I appreciate that 100%. My concern is if we know that we're running up against that clock that runs out on the 18th of August, is there a way that the government can now, or the Commonwealth can now ask the government to extend that order again? I don't want to be in a situation where you finally make a decision.
I think the Commonwealth understands that.
Yes.
And I invited you the last time to seek to intervene or to do whatever you needed to do to communicate your concerns to the feds.
I understand that, and that's what I did, Judge. I had a conversation with the U.S. Attorney's Office, had a conversation with their attorney, and the plan was if we did not hear back in a way that was reasonable to us, both myself and Attorney Sullivan planned to file a motion on Wednesday to intervene.
Okay, great.
That was what we were planning on doing. So that's before we knew that they weren't going to have a meeting until 4 o'clock on Tuesday, Judge.
Yeah. All right. So do you want to set a date? Do you want to say the 12th?
I think the 12th at 2 o'clock, just from my reading of the emails that was going around yesterday, seemed to be the best.
I think that's what Ms. Irwin said.
Sure. Yes.
Okay. So we'll put, let me just see, we will put...
Except for Mr. Wester, I do want to say, who will still be on vacation.
Right. We will put King, De Los Santos, Johnson, and Chanchillo, and I think also Walsh.
Yes, please.
On for 2 o'clock on the 12th, on the issue relating to the federal Proctor discovery.
Yes, Your Honor.
Thank you, Your Honor.
And
All right.
is there any way to get an update from the 4 o'clock meeting today, Judge, so that we're not waiting until the 11th or the 12th, the morning of the 12th, to find out what happened?
I'm sure that the Commonwealth will alert folks to whether progress has been made. Everybody needs to be on the same page ultimately for the
I
hearing
think
on
it's
the 12th.
all the
and you're gonna
cases
have to act
Proctor is
quickly.
involved
The
in
Commonwealth
that
may
they're
have to
trying
act
to
very quickly,
postpone
depending on what happens.
because they're
And I
having a
am doing
meeting at
that.
4.
Yeah. Okay. Thank you.
Thank you.
Thank you, Your Honor.
All right.
There will be the
Uh,
morning meeting.
Now,
Might
with
not be
respect
the
to the
12 o'clock
King
meeting.
matter, we're just dealing with the issue of the late disclosure. And
May I be heard, Your Honor?
sure.
At the close of the last hearing, you asked the defendant to provide the court with which documents were either exculpatory or would inhibit the defendant's right to a fair trial, would be prejudicial to him. I have not heard of one document since these have been provided in April and May. And to that end, I'd ask the court to order that right now. I think that this has gone on, this is now the second day of a hearing, and the Commonwealth is unaware of which document or which documents are prejudicial to the defendant and will prevent him from having a fair trial.
We had two things I was looking for. I was looking for that, and I was also looking for some sort of a agreement of the
I
parties
can't
that was worked
stream the
out
Boston 10
to
video. It doesn't show up when I
identify
go
which of the
into it.
documents were newly disclosed,
And Boston 10
which were
YouTube
partially
doesn't have
disclosed
this live.
previously and fully disclosed more recently. And then there was the prejudice analysis as to the new documents.
Correct.
So there was sort of a two-phased process. I don't know whether either one of those phases happened, whether the parties met and tried to work out an agreed list as to what was new or what was not new.
I endeavored to work with ADA Hickman to ensure Your Honor had a complete list as diligently and as best as we could of what documents were previously produced, and that was provided to Your Honor. I believe it was sitting on your desk as Monday morning. It was a third exhibit that the Commonwealth provided. We did confer on Friday afternoon. It was represented to me that counsel would be providing us a disagreed list or a number of other lists to show the court what they disagreed with.
I got a pile of documents.
And we got that as well.
This is the pile that I got, I think, from Mr. Piccio's office. I don't know if included in there is the chart that you folks worked out that you say was on my desk. I'm not sure I know what you're referring to in terms of a list that was new or not new, but maybe it is in the stack.
It's a table, it's the third. If you look in the manila folder that's underneath that, there, in a rubber band, it's in your hands right now.
Oh, in here, okay, this one.
That, yes. The third doc.
Okay,
That is what I prepared with the assistance of ADA Hickman.
okay.
Which specifically describes
Doesn't show
what,
up
if anything,
on the YouTube. Are you sure you're not looking at their webpage?
different. That was provided to counsel on Thursday last week. We met we got a teleconference on Friday, and counsel was working on their own lists.
Okay.
So to answer your question, no, there was no agreements as of now. We endeavored to meet earlier and understand from my pleading.
Boston 10 is
counsel
locked in my
disagreed with,
country for the live video.
But that was not reached. We provided you, the Commonwealth has provided you as best we can what has been previously provided.
Okay.
If there's any subtle differences, we can supplement that at a later date. But at this point, I know ADA Hickman has worked very hard
All right.
to go through the material.
Attorney Scapicchio?
Thank you, Your Honor. So we've provided 3 charts, both to the Commonwealth and to the court. The first chart deals with the information contained in the Commonwealth's opposition in disputed documents from pages 7 and 8 of their motion to dismiss. The second chart deals with all of the new discovery, which I thought we were in agreement that the second chart is everything that was new, it hasn't been disputed by the Commonwealth. And the third chart is the information.
So you have 2 dueling charts, huh? So you have the Commonwealth chart and your chart.
Yes,
This is exactly what I didn't want to have happen.
I understand, Judge.
So why didn't you get together and work, figure out a...
I tried you.
Well, I think we both tried. I'm playing catch up here, Judge. They've had this information since 2021. I'm trying to go through it, organize it, and figure out where it fits in the most timely fashion that I can. And that's what I've spent my time doing. So when we spoke on Friday.
Do I have a list of the items which are new or which you claim to be new and that I can then cross-reference against the Commonwealth list, which you say are prejudicial or are exculpatory and you're behind the 8 ball because of the late disclosure, notwithstanding the continuance.
Yes, Your Honor.
Okay, where will I find that?
So where we find what, Judge?
Your list of the explanation of why particular things are prejudicial to you.
That hasn't been completed yet, Judge.
Okay.
I just got to the point where I was able to send a list to them literally Monday morning saying, based on everything that you provided since April, here's what I think is new, and we all agree it's new. That's chart number 2. Here are my disputes from what you say you already gave us from the first part of your motion. and here's what we say is new from the second part of your motion. That's what I was able to accomplish in the week that we had between now and the last hearing.
All right. So you need more time to get the other stuff done.
I do.
Okay. How much time do you need?
It depends. I just got more discovery this morning, Judge, so it just keeps happening. So in order for me to get my hands around it, they have to be able to certify that I have everything, Judge. So I can't keep doing this piecemeal the way that they've asked me to do it over the last month and a half. So do we have everything? Because if we do, I'm happy to sit down and say, this is where we are and this is where we stand. But if we don't have everything and we're going to come back in a week and they're going to hand me something else in the morning of the hearing and say, this is,
well,
now
as an initial crack, I wanted a list of what was new and what was prejudicial in the two notices as of when the motion to dismiss was filed.
Yes.
That's what I think we were shooting for. We understood that some new stuff had been produced after that.
Yes.
I don't know what the explanation is for that, but in any event, we're looking at what was filed as of the time the motion to, what was new as of the time the motion to dismiss was filed.
So Judge, what I did with the new information is I put it in chart 2 as just a description of it. I cross-referenced it to a base stamp number if we had it, and I put it in a discovery category, which is I thought what the court asked me to do. So some of it has to do with jail calls, some of it has to do with social media, some of it has to do with search warrants. I've categorized it in a way that I think that I was hoping it would help the court understand.
Can we make a record here?
Yes.
You were referring to lots of stuff which is not in the record.
Correct.
Right? We admitted in the last hearing exactly one document.
Yes.
Right? If you are referring to particular charts, let's be clear about what they are. Let's mark them as an exhibit, and then we'll discuss what we need to do. You can explain what those documents are to me without a witness. I think that's sufficient, and then we'll decide whether we're going to proceed with the hearing on an evidentiary basis today or not.
Thanks.
Oh, I'm sorry.
But again,
all right. So I've been handed 3 charts.
let's just give it.
Chart
give
1,
them something.
chart 2, and chart 3. You're moving their admission?
Yes, sure.
Okay. Any objection, at least for the record here?
No objection.
Okay. So these will be marked as, unfortunately, exhibits 2, 3, and 4, because we already have an exhibit 1.
And may I admit the Commonwealth's exhibit? That's the chart.
This is the Commonwealth exhibit.
Yes.
Any problem with this?
No, Your Honor.
Okay. So this will be exhibit 5.
Thank you, Your Honor.
Well, welcome back to Massachusetts, where we file everything the day off and don't throw over evidence. But let's get to the meat and the potatoes. And for everyone who's coming in asking, read the banner. EU has a stupid rule that they made against news sites from America because of fake news. So they either have to have a certificate or they will be sued. So we can't watch a lot of news sites in America. It's abso-stupid-lutely. And I can't watch it on YouTube either because it's geo-locked for me.
All right. How do I deal with these charts? How do I read them? They look like you're talking past each other to some extent, that they're not, so if I look on exhibit 2, which is the defense chart number 1, discovery address in Commonwealth opposition to our motion to dismiss. Item 1, copy of search warrant affidavit for T-Mobile cell phone, draft affidavit. What does this tell me?
So what that's meant to tell you, Judge, is that the Commonwealth is, in their pleadings, are indicating that we actually got the search warrants. We didn't get the search warrants.
No, hold on. Not argument, just what does it show? Document description is received by King.
Right.
What is that? What's in that column?
So that column is what we actually received as opposed to what the Commonwealth is claiming they gave us. And it's categorized.
No,
So the Commonwealth is claiming, so
slows
for the first
everything
two,
down.
Judge, if I can just show you. For the first two, the Commonwealth is claiming that they already provided those search warrants to us. They haven't provided the search warrants to us, Judge. In fact, what they provided to us was,
No. Just slow down. I want to understand what Exhibit 2 shows.
so Exhibit 2 takes the Commonwealth's opposition.
What's in column 1?
Column 1 is the description that was received by us.
You're
from the
quoting
Commonwealth.
something from what?
Discovery notices, Judge.
Draft affidavit for search warrant 21 SW. I'm sorry, you're quoting what?
We're quoting what the Commonwealth named these documents in their opposition, Judge. That's what the Commonwealth named these documents, to try to convince the court that we already had them.
Yeah, they were just redacted in white. They weren't blank. He's probably going to say that the next time.
Search warrant stuff down there. The two.
Okay, and you don't have any Bates numbers here, so I can't go and find these things, right?
Right, because the Commonwealth didn't have the Bates stamps in the ones that we did.
We're still
If you look
talking
down
about
to the second column,
discovery.
we do have Bates stamps. There were some things that were given.
Second column,
Second part of the chart. We were able to provide Bates
second
stamps.
chart, or the?
No, just where it says
Second
noted
part.
4925.
Listen.
All right, so how do I compare what you have to what the Commonwealth has provided me? I need you to be on the same page. I need you to go through every single document that was produced that you base your motion to dismiss on. Every single one.
Mhm.
You have to address every single one.
That's what he
okay?
ordered them
And
the
you have to
last
make
time.
a chart saying, this was produced in Discovery Packet 1. This was never produced before, okay? I don't need argument associated with it. I just need to know the universe of the problem. I need to get my arms around the scope of the problem. And then I need to know, with respect to anything that's new or substantially new or partially new, why you're prejudiced by the late disclosure of that additional information.
Understood, Judge.
So I don't have that here, right?
I thought you did. I understand now you don't follow it the way that I followed it.
Well, I don't understand it. So I need you to explain to me why you think I do have that, if I do.
Well, I think you have part of it, Judge. I don't think you have all of it.
All right. So I need all of it.
Okay?
Okay. So I understand the scope of the problem. And then I can analyze the question of prejudice.
Well,
after you've analyzed the
I think he's
question of
mad
prejudice.
at both
Yes,
of them,
Judge.
but she's the only one arguing.
So how are we going to do this?
We're here at 9:24. I'd be happy to meet with the parties downstairs for the next 3 hours.
I think it would be a much more productive use of time than putting Mr. Lally back on the stand
No,
or anybody else,
no.
because there are real constraints on the court's ability to provide a remedy beyond the remedy that has already been provided, absent real showing of meaningful prejudice. And so I need to understand where that prejudice is coming from. And so you're welcome to spend the next 3 hours doing that.
Sure, Your Honor.
Okay. I know everybody's here. I know we have witnesses here. I'm sorry about that, but I think we need to do this in a logical order.
Thank you, Your Honor.
I have a hearing at noon, from noon to 1, where I have to finish an evidentiary hearing in another 2 co-defendant case. That'll take me from noon to 1 o'clock. I'm happy to see you at 2 if you're able to make substantive progress between now and then, or I'm happy to just see you on the 12th.
Just push it to the 12th. It's not going to happen.
But the 12th would not be for evidence. It would be for an explanation of the analysis that you've done on all the various documents that were apparently produced late.
I don't know where we'll get it. I mean, we could let the clerks know if we could.
I'm happy to report back at 2, Judge, if that's what you want us to do.
Yeah. I would like to release the witnesses.
Yeah, I think you should release the witnesses. I think and I think, frankly, I should see you on the 12th, because if you're not done by 12 or whenever today, we're going to be together on the 12th. It's the soonest I can see you after today in any event, and it'll allow you to do the prejudice analysis, because that's the first part of it. That's great. Everybody's on the same page as to what's new.
Mhm.
And then I need to hear from defense counsel, document by document, as to why it's prejudicial that this was lately disclosed.
Yes, Your Honor.
Your Honor, if I may, I believe we have one outstanding issue that was brought to the court's attention, and I believe Attorney Moynihan is here.
We're none.
We had the order of Judge Doolin of June 17th relative to Mr. Proctor's personal phone, and Attorney Moynihan has filed a motion on our last date relative to that order, and I wondered if we could address that today. It's the one outstanding issue that we have on Judge Doolin's June 17th ruling relative to Mr. Proctor's personal phone, Your Honor.
Judge, I didn't know we were addressing that today.
My understanding on the last date, Your Honor, is we put it down for noon because Attorney Moynihan would be here, and today would be the day that we'd be addressing this issue relative to Judge Doolin's order. I believe I asked the court on our last date whether or not this needed to go back to Judge Doolin, and Your Honor indicated that you had read the order and felt that you could make a decision.
Frankly, Your Honor, I didn't get notice we were addressing that today.
Would you like to be here on the 12th also?
Well, he has to be a
Check,
protest
but if I could be
testify.
available, well, but that would be a better day than today.
Okay.
You want to try it? You have your calendar?
Sorry,
You have your calendar?
I'd have to just call my office.
Okay. Let's put it on for the 12th. Call your office. If for some reason you're unavailable, let me know. I'll get back on the bench and we'll set another time.
Is that 2 o'clock, Your Honor?
It would be 2 o'clock, yes. I have the papers here. I didn't read them for this hearing, but I will take a look at them now. So if you decide you want to be heard today, I'll hear you on it.
I prefer the 12th. I can let the clerk know if I'm available to it. We do that 10 days.
Okay, all right. So if you can be available, we'll hear you on the 12th. Otherwise, let the clerk know and I'll hear you now. Okay? Okay. Anything else we can do today? Thank you.
Thank you.
Court authorized.
Moynihan.
Well, we didn't have to yell at each other about NBC 10. We didn't have to get our popcorns ready because what they were ordered to do the last time, they haven't done. If it's on the state or on Rosemary, I don't know. They were ordered, and I remember this as clear as my name is John, that they were to sit down together before the hearing today, look at all the evidence and say, we have this, we don't have this, and we have gotten this late. And this is why it prejudices our client. What we got now was all the homework you were supposed to do, you can do in class, and you'll come back and have school on Saturday. That's just stupid. So, not much we can talk about, really. AJ is joining Karen Reed's civil team. You probably all knew that because he alluded to it yesterday on the Twit that he was doing that. And we don't know. We know something has been filed. It's been filed in federal court. So we don't know what it is. But hopefully they have some good stuff. I don't know what, as I said, a lot of people are believing that, well, she's going to sue for this or for that. In reality, it's really hard winning a case like this over the state. I don't think that Lally, now I'm being stupid. I don't believe that AJ would file anything if there isn't a high likelihood that he can at least give a good punt at it. But is it that Karen Reed will own Massachusetts Monday? No, it's not. A lot of people out there says, well, they're going to get Bev for corruption. Most likely not. Well, tortious, malicious. They shouldn't have been allowed to try her the first time. Well, potentially that could be something because people lied to the grand jury. We know that because Carrie admitted that she lied. So at least there's that. That could potentially be an avenue, but don't expect that Karen Reed will own Massachusetts. And I could see that she most likely will have a settlement, maybe recoup the money she spent. But how big, how small, I don't know. We will have to wait and see what he filed. And if I'm a little distracted, it's because we, of course, are ready to go to a new trial because, hey, we are a trial covering channel, and I just have to set up a new thumbnail because I was planning on one trial, but that's already been But yeah. Lally for sure was helping with his testimony in the King matter last time. I mean, to get the prosecution into the lawsuit, normally you only sue the police, not the prosecution. And I think, yes, and that's why they fight tooth and nail to keep Lally out of this, because he effed up the last time. He really effed up the last time. And he showed that they were not doing what they're supposed to do at the law office. I'm not yelling at Marissa. Feds need to go after. Won't happen, most likely. They still haven't arrested anyone but one in the Sarah Birdsmore case. Don't trust the feds. Don't believe the feds. So the judge just doesn't care about the late discovery. Yes, he does. And what he actually wants is both sides to sit down so he knows exactly, out of those 260 pages that they claim were 260 items that was turned over late, which is turned over late, what is perhaps a Rule 14 motion. He actually wants to get he wants to narrow it down so we are not, I'm sitting like doink right now. He wants to narrow it down so we don't have to discuss everything. What was turned over late? What can they prove they have turned over in time? And then we can go on to that, because those 6 search warrants, why is it prejudicial and was it turned over late? Okay. They can say, we didn't get it till this, and then they never turned it over. It's prejudicial because of this. And then we can move on from that. So what he is actually asking them to do is go and sit down, and if the state claims we turned it over, then the state will have to show Rosemary that she got it on the 5th of February last year. And she can say, well, I didn't get it. I don't know where you sent it. I never received any of that. And then they can go back to the judge and say, well, the state believed they had sent it on the 5th of February, but it must have disappeared somewhere in the ether. And that's what they have to go and figure out now. Proctor just had his appeal hearing. That's why they are trying to keep both off the stand. However, Proctor is on ABC stating he would do nothing different, which means planting evidence is fine. Well, Proctor hasn't been found guilty of planting evidence. This is what we believe happened. But as I talked about yesterday, what the court found was Karen Reed didn't hit John O'Keefe. The court didn't find that the Commonwealth planted evidence. The court didn't find that Brian Albert did it. The court found that Karen Reed didn't do it. So you will have to then have someone prove that Proctor planted the evidence. And he didn't get fired for planting evidence either. He got fired because he was a shitty police officer. And we sit here and talk about all these things that we believe happened, but they are not facts just because we believe it. We are not Matlock. Proctor haven't been found guilty in planting evidence, and that's important to understand, that all of the things we talk about, could it be Colin who did it? Is Chloe really alive? All of that stuff is for us to debate, but it hasn't been proven in a court of law. So none of that can be used as evidence until they can prove it. Proctor didn't want to go on the stand because Proctor will be met with questions like, why didn't you turn over 6 search warrants? You don't have to have him do all kinds of stuff, because a search warrant is an automatic Rule 14 motion, or a Rule 14 evidence, which means it should be turned over automatically. You don't have to hide it. You don't have to do anything. You don't have to ask for it. That is just placed in your hand saying, here you go, this is the search warrant. You can then speculate, why don't Proctor want to be asked about why he only turned over 2 partial search warrants to Lally, and why did Lally accept 2 partial search warrants when he knew 6 search warrants was filed, and each of them are Rule 14 material. That's the question that you can ask, and that Rosemary will ask. But tail lights, funny phone calls to kind of set up a timeline, we can sit and deduce that is most likely what happened, but you can't present it as evidence in a case because it's not proven. But you misunderstand what a trial is about. A trial is not about, but if she didn't, then who? A trial is about, she didn't do it, or she did do it. This is what the trial have determined. Karen Reed didn't do it. If you want to say, well, as reasonable people would say, we believe the cop who is not part of the CPD, who said the tail light was 80% intact. But who are going to investigate who put it there? Higgins? Bukaki? All of this is what we deduce because we use common sense. Someone must have planted there, but you can't use it in a case against him because it's not proven in the court of law. Yet he wants his job back. He needs to move and get a new job, so that's nowhere near law enforcement. Well, what I heard yesterday, he seems very, very deluded about what his rights and roles were. Morrissey has his paws in all of this, yes. So even when Krusty claims that he doesn't really have anything hands-on with the cases, he's the head of the job. Elon Musk is the head of Tesla. So it's Elon Musk when you get mad at your Tesla for being a bad car or whatever it does. I drove in a Tesla when I was in the States. I like that one. I don't like the one I've driven in Denmark. It's Elon's problem. Everything bad happening in the DA's office is Morrissey's problem. Just want to see Proctor understand and questioned by Rosemary. We all do, but it's not going to happen today, sadly. Look like Hickey Bear might be the culprit. Yes, but you would have someone, which would be the feds, to come in and try and solve the case, and the feds are not going to do that. The feds don't care. I know a lot of people are thinking, well, the feds are kind of safe. Maybe you listen to a certain alcoholic at the coast who claimed that the feds are going to sweep in and would save Karen Reed. It's not going to happen. The feds don't care. The feds are government. Do you think the government care about that? We'll never know because Lally didn't do his job. Exactly. And we'll never know because the one who might have been dirty is Proctor. And he's the guy who investigated all of it. So, yeah. I'm just very disappointed that this is the case, or this is the same motion that was made the last time we watched it. Go home, figure out who the hell did what, and did you turn over the evidence at the right time? And now they have to do it again because no one does their homework. And I'm annoyed about that. Rosemary had made a package of things that she meant hadn't been turned over, and the judge was just like, I don't care. Feds and cops doesn't get along, so anytime the Fed can get the cops, they will, though. So who knows? Again, if you don't know the Sandra Birdsmore trial, try and look it up. Sandra Birdsmore was seriously no. Sandra Birdsmore was unalived by a cop, but he wasn't alone in hurting this poor young woman, because fellow cops also used her for sexual gratification. So if the feds are out to get cops, why haven't they gotten any of the other ones? It's been, how long has Farrell been in Farwell been in prison? I think he's been in prison for close to a year. So I'm not sure that things is going to happen as fast as people believe. So I'm just saying, gird your loins. It's not going to happen as fast as people think, and I don't think that that the feds are going to come and save anyone. Why the hell can't I do that? Farwell got punched to October 21st, 11, something like that. Please get your loin girder. Yeah, October 2024, and nothing has happened. Yeah, and the feds didn't even sweep in till 2.5 years after. So just because we have all this, well, there's intergovernment bad relationship. No, they're not going to come. Hey, Tom, They had to rush to indict Farwell because everyone was going to find out the feds were sitting on 30,000 disgusting text messages. They were just turned over to the family when the feds rushed. Well, then why didn't they rush to get his brother or the two other named in that case? I just don't get it. I don't, let me be honest, I don't understand why people trust the feds. I have been covering Karen Reed and Massachusetts for 3 years now, almost. And I hear the feds are going to come. Every single time we talk about it, well, the feds are going to come. They're not. The feds are not going to come, swoop in, and save the world. The feds don't care. They can't even get Farwell in a courtroom. They agreed that they agreed to postpone the last hearing, both of them. So they're in no rush. I don't know if they hoped that he had something that they could use against someone or whatever it has happened, but I don't think. Do we know that Farwell waived a speedy trial or not? Well, they just agreed to postpone the next court meeting till October. So yeah, maybe his brother talked, maybe he didn't. We don't know because no one knows. The wheels of justice grind slow, but they grind increasingly fine. I don't think so. I honestly don't believe that any more fallout will come for Bukaki, Tully, Fanning. I think Proctor will be the sacrificial lamb, and then everyone is going to do this and say, yeah, well, he was a bad guy. The rest of us, we're good people, though, right? We're the ones you can trust. Sorry, I'm just setting up a stream. The 9 most terrifying words in the English language is, I'm from the government, I'm here to help. Yeah, that was a good one by Ronald Reagan. The released witnesses are for today. So they didn't have to sit here and wait till they were done discussing what was going to happen. They're going to come back at 2 o'clock, 1 o'clock, and say, well, we looked at it, Your Honor, and we have agreed that X or Y. And then he said, well, gonna see you again on the 12th, and go home and keep working on it because we need to figure this one out. Feds can bring murder charges. That's what they did. Half of all unalivings go unsolved in America. It sucks when some stranger you care about try having it on your own family. Yeah, that's sadly how it goes. Most of them will, well, not most of them. Half of them will never be solved. And which has the worst rating in Massachusetts? Norfolk County. Surprise, surprise. Got to get on the cassette. Yeah, but Recovery Addict is covering then, so I'm gonna jump on the Sheila Agee instead, who told her son to unalive his baby mama. It was supposed to be the Cassatis case, but Recovery Addict is covering that. So to give people something to choose from, I'm gonna jump on the Sheila Agee. Allegedly encouraged her son to unalive Brooklyn Sims, the mother of his child. That's she apparently texted her son calling him an MF B word if he didn't go through and unalived his baby mama, and she was then later pew-pewed in broad daylight. So 2 crazy cases. If you want to see the Casotis, which seems like a good case, crazy case, Recovery Addict is covering that. If you want to see the Sheila Agee case, I'll be jumping on that. We'll go back and it has started, but we'll jump back to that one. So giving you options instead of just sitting 2 people and covering the same trial. Hey, 007. Karen could be any of us, Sandra, our daughter and family member. Exactly, and that's why it's so important. Well, thank you for that. Isn't Aaron Spencer starting next week? No. There will be I think there's a potential hearing next week. I don't think that's set till... Can't remember when it's set for. Aiden has a court date next week. Yeah, 007, the defense said that the Commonwealth just have given them another 300 pieces of evidence in the last 4 months when they could have given them at any time. So the judge told the defense, I don't need your charts. I need you to talk to the Commonwealth and tell them why you believe it's exculpatory evidence that wasn't turned over, and I want you to sit down and come back, and then I want to know what it is that we are talking about. I don't want everything, just want the things that we believe is a Rule 14 violation. No, I'm going to start a new stream, Zach. Yeah, I'm going to redirect you to another stream. I'm just having a short pee break. And then we are going to start up with the Sheila Agee case, a mother who apparently told her son to go unalive his baby mama. And it's going to be fun. Maybe. It's going to be crazy. But hope I see you over there.
What exhibit are you referring to? Exhibit are you?
I'm going to make this 100. I'm going to make this 100. 100. 100. It is 100%. It is 100%.
So you literally built a cannon?
Yeah, it's pretty awesome. Yeah, it's pretty awesome.
Go back. Please go back. Do that again. Please do that again. See this thing routine. See this thing routine.
While I'm waiting for this, did you, whether it's true or not, believe it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother? He slept with your mother?
Probably did. Probably did. Everybody has. Everybody has. Everybody has.